Hello, welcome to Brass Tacks. I'm Zaka Jacob. The ongoing political tussle between governors and various state governments of various opposition-ruled states now seems to be hitting a decisive legal turn. The Supreme Court yesterday issued strict instructions to the governor of Punjab, saying that he cannot indefinitely sit on bills, and in case there are differences, he has to refer the bill back to the concerned legislature. The court in its order also made it clear that governors do not have any virtual veto powers over the legislature. The question that needs to be asked then is, will this set the template for governors in other states, in Kerala, Tamil Nadu, and other states where governors have been at loggerheads with their respective state governments? But first, the story so far.
This is complete travesty of justice with travesty of democracy. If the governor is sitting on these bills forever, such inordinate delay is only decaying the democratic process.
Let's take a look at what is it that the Supreme Court actually said in its order against the Punjab governor. Number one, it said a governor is an unelected head of state. That's the word that was used by the Supreme Court. It went on to say that the governor cannot use his or her office to thwart the course of lawmaking, that governors cannot be an impediment to the process of lawmaking, is what the court has said. It also went on to say that yes, governors can advise the reconsideration of any bill, but they must immediately refer those bills back to the legislature. The governor's advice is not binding on the legislature. So as per the Constitution, if once the governor feels a bill has to be reconsidered, it can be sent back to the legislature. And if after that it has still not been reconsidered, then yes, the governor has to give his or her assent to it. The legislature will alone decide whether to accept those recommendations made by the governor or not. Withholding assent is without recourse against democratic principles. The court also went on to say that a virtual veto power over legislature, that is against the Constitution. And it went on to describe that governors have no virtual veto power over state legislatures. Now, how did this come about? How have things come to such a pass that the Supreme Court had to issue this order? This started with the Kerala government taking the Kerala governor, Arif Mohammed Khan, to court on the 2nd of November earlier this year. The Kerala government moved the Supreme Court, claiming that the Kerala governor, Mr. Khan, was sitting on as many as 8 bills, refusing to give his assent or nod. Now, similarly, a couple of days prior to that, on the 31st of October, the Tamil Nadu government took the Tamil Nadu governor, R.N. Ravi, and remember, he's been at loggerheads with the state and the chief minister there. They moved the Supreme Court, the Tamil Nadu government, against R.N. Ravi. The government's claim in the Supreme Court is that he is again sitting on as many as a dozen bills, refusing to give his stamp of approval to at least 12 bills. The Punjab case, for which the order came yesterday, that was moved by the Bhagwant Mann government on the 30th of October 2023. The Supreme Court was moved against the governor, Banwari Lal Purohit. The Punjab government's claim is that the governor there is not giving his assent. He's delaying as many as 5 bills. The government claimed in its argument, the governor referring to a special 2-day session of the assembly as illegal, that the government had taken great offense to. Also, on the 2nd of March, Telangana had moved the Supreme Court against Governor Tamilisai Soundararajan. The government of Mr. K. Chandrachud Rao, its claim in its petition in the Supreme Court is that the governor, Tamilisai Soundararajan, was delaying the assent to as many as 10 bills that have been passed by the State Assembly. So that brings us to the big question we're asking tonight. Has the Supreme Court drawn the line for governors, what their role is, and whether or not they can sit on bills? Now, Article 200 of the Constitution, it says that bills have to be returned as soon as possible without setting a time frame. The Constitution, mind you, does not say it has to be returned within a week or within 10 days or within 3 months. It says as soon as possible. Then the Supreme Court ruling from the Punjab matter yesterday saying that a virtual veto in the case of the Raj Bhavan delaying assent goes against constitutional principles. Now, what this means is that the demand of the states, which was the petition by Punjab and then subsequently, of course, by Tamil Nadu and Kerala, was to set a timeline to instruct governors, the Supreme Court, to frame orders in a way that there has to be a definitive timeline for assent to be given by the governors of various states for bills that have been passed by their respective state legislatures. Now, former Union Minister P. Chidambaram has tweeted on this, and that is part of our Motorola India's Best 5G Smartphone Brands tweet of the day.
Hello, Moto.
All right, this is what Mr. Chidambaram has tweeted, and I quote, "The judgment of the Supreme Court on the governor's powers is a stern rebuke to not just the governor of Punjab, but to all governors. Mr. R.N. Ravi, the governor of Tamil Nadu, should read every line of this judgment, and if he thinks it necessary, call a competent senior advocate to explain the judgment to him," end quote. So let's get to our big debate tonight. Has the Supreme Court now set the basic ground rules for what governors can and cannot do in the context of sitting on bills and refusing to give their assent?
Hello, Moto.
All right, our full panel joining us on the debate topic tonight. YG Madhuvanti is a member of the Tamil Nadu BJP. Salman Soz, national spokesperson of the Congress Party. Tathagat Roy is former governor of Meghalaya and Tripura. A. Saravanan, spokesperson of the DMK. Kapil Sankla, senior lawyer in the Supreme Court. Mr. Roy, let me start with you first. In your capacity as a former governor, the orders yesterday by the Supreme Court are very, very explicit, very clear, that the office of the governor cannot be used to thwart the course of lawmaking. That yes, the governor can advise reconsideration once, but if the bill is sent back to him a second time, then he has no choice, or she has no choice, but to give assent to such a bill.
See, in my view, as far as I have been able to see, it is not as if the Supreme Court has said something absolutely new. The governor always had that right to go over a bill which has been passed by the assembly and thereafter give his assent or go into certain alternative methods. Now, among these alternative methods, one was sending it back for reconsideration with or without suggestion. The second one was to send it to the president for consideration or for analysis or whatever. I don't remember exactly the language which was used. And he could use his discretion in certain matters which are not material in the case that the Supreme Court decided. I'll give one example from my own experience, an experience that I had as the governor of Meghalaya. The Meghalaya Assembly, and that too unanimously, had passed a bill which was called the Meghalaya Resident Safety and Security Bill Amendment. According to that, the persons from outside Meghalaya coming into Meghalaya had to register themselves in the police station, failing which they would have to would be subject to certain penalties. Now, I went through the Constitution and very carefully and took legal opinion also formally and informally. And then finally I said that this is not a thing which is there on the state list. On the other hand, this is on the union list. So the assembly cannot legislate on this question. And therefore, this is outside the frame of reference of the assembly, and I cannot give it assent to it. But because the Constitution requires me, gives me a recourse to send it to the President, I am sending it, and then I sent it.
So, A. Saravanan of the DMK, there is state list, concurrent list and union list. where there are matters that come in the concurrent list, why should the governor not have powers to decide? As Mr. Roy said, there was this example that he cited of a bill which he felt was not in the state list, and yet the legislature had passed that bill. He then referred that matter to the president for reconsideration. So there are many such instances that come up, bills that get passed, which may not necessarily fall in the domain of the state legislature, or it could be constitutionally challenged whether it is falling in the domain of the state legislature. The governor has powers to ask for reconsideration of those bills.
Yeah. See, Zaka, the Supreme Court has admonished the governors, all the governors who have been appointed by the BJP, especially in the opposition ruled states. They should read the judgment given by the Supreme Court 2 days back to back, every letter, and they should follow that judgment in letter and in spirit, because they don't have a choice. And when Mr. Tathagata Roy says that he has referred it to the president, when it is in the concurrent list, even if it is in the concurrent list, only if there is any central law, union law, which is against the state law, that legislation could be referred back to the president. Otherwise, until there is a union law, that is, the state law will prevail. This is the elementary legal principle, and I think it is wrong. Now the question is this: the governors are not elected, they are the only constitutional functionaries who are appointed, who don't require any other qualification. The president is elected, everybody else, a qualification is prescribed. There is no qualification that is prescribed for a governor except that he should be an Indian citizen and of 35 years of age. The expectation was that the union government will appoint people with dignity, people with decorum, people who will uphold the rule of law and the constitution. But what is happening?
But Saravanan, is it your contention that governors should just be merely a rubber stamp giving assent to every bill that a legislature passes?
Yes, Zaka, you are right. The governors are mere rubber stamps. They are postmen and yes masters. They don't have any other role. This is what the Supreme Court has said now.
May I respectfully beg to differ? Yeah. There have been instances, multiple instances of dissolution of assemblies, which governors have rubber stamped. It has gone all the way to the Supreme Court, and the Supreme Court has struck it down. So I don't think we need rubber stamp governors, but be that as it may, I think I take your point. Let me ask YG Madhuvanti, and I'm going to quote.
Let me finish this.
I'm going to quote.
Zaka, let me finish this.
Okay,
Give
quickly.
me 10 more seconds.
Quickly, 10 seconds.
10 more seconds. Yeah, see, the problem is when the governors act as a super CMs, they want to withhold. See, they can't withhold. If they withhold, they'll have to send it back. That is what the Supreme Court has said. But what the governors of the BJP are doing, they are sleeping on the bills. They are putting it beside their pillows and sleeping after getting paid extravagant money.
So let me ask YG Madhuvanti, and I'm quoting from the Punjab order that came out yesterday by the Supreme Court, that the governors can advise reconsideration but must immediately send back the bill to the legislature. The governor's advice is not binding on the legislature. The legislature alone will decide whether or not to accept these recommendations. And the most important thing that the court said in its order yesterday, a virtual veto by the governor over legislature's functions is against constitutional principles. So the court is very clearly laying out that yes, once the governor can raise a request for reconsideration, but the second time, if the bill is sent back to him, he or she has no other recourse but to give their assent to the bill.
So, good evening, Zaka, and good evening to my fellow panelists here. I don't think we can compare and cut and paste what has been told to Punjab to Tamil Nadu here. I think we've already had this discussion a couple of months ago on your same channel. Bills that the governor has not yet passed his assent on in Tamil Nadu are completely different from what has happened in Punjab. Let us be very clear that some of these bills, rather most of these 10 bills, so-called bills that are being spoken about, are asking for the governor not to be in the post of chancellor, to remove himself from that post and to make the Honorable Chief Minister of Tamil Nadu the chancellor and appoint vice chancellors of their own will and wish. Now, how is this allowed as per the Constitution of India, which has been framed by Sri B.R. Ambedkar, whom the DMK worships as their godfather? I really don't understand. And trying to make this a political issue, I think the governors of any state are beyond politics. They are not puppets and they are not answerable to the political party, but they have to follow the constitution and the system. And if you think that a governor in a state is only there to give you tea parties and luncheons, that's not the case.
But ma'am,
and
the
that's certainly
DMK's
not the case.
contention is, for example, this online gaming bill that has been that the governor has not given his assent to. What is the problem? It comes under the
Sir, why
state
is it that the
list.
DMK? Why is it that the DMK government is not answering my question? How can you make the chief minister of the state chancellor and
I will
appoint
answer
your
that.
own set of vice chancellors?
Zaka, I'll answer that.
Okay,
How is
Saravanan,
that
quick,
allowed?
quick rebuttal. I've got Kapil Sankla and Salman Sood also to go to.
Zaka, the constitution did not appoint the governors as vice chancellors. They have been appointed as vice chancellors by the statutes of the state government, and any elected assembly has got the full right to amend. They can make anybody as chancellors of the universities. It was made by a statute and we want to amend that statute. The governor has no business to withhold it, stating that I am giving my away powers. Who are you? What way you are associated? You are not even worried about the welfare of the people of Tamil Nadu.
No, but Saravanan, every state in universities across states, in Tamil Nadu, in Kerala, in Bengal also, this was a big issue some time back, where governors are chancellors of universities. There have been clashes, particularly on appointments, more than anything else, on appointments between governors and state governments. Eventually, you find a way out. The solution to that problem is not removing governor as the chancellor of state universities. The solution to that problem is to arrive at a consensus, to have an expert committee and look at competent appointments and make those appointments, not to remove governors as chancellors.
No. See, that's what Zaka. Let me clarify this. See, the governors, if they are, so far we have for 70 years of independence, we did not bother to worry about who's going to be the chancellor. But when there is a mischief monger as the governor who wants to scuttle the administration, we will not sit and watch.
Okay.
And we will not allow this to happen.
Let me go to Salman Sood. The whole purpose of having an unelected constitutional head of state is that they have a constitutional obligation, a duty, that sometimes elected politicians, and let's face it, elected politicians have a lot of political compulsions. They need to play to populist tendencies. They need to play to the galleries, as it were. That all of those decisions may or may not be in line with the Constitution, with constitutional provisions. So governors have a constitutional duty to ensure that every legislation that is passed in an assembly aligns with the Constitution of India, that a bill that's passed by the legislature, if it appears to violate constitutional provisions, then the governor is well within his or her right to legitimately withhold assent. Governors can also withhold assent if there have been procedural lapses in the legislative process of passing those bills, whether it is insufficient debate, not reference to standing committees, whether there is a lack of transparency in the manner in which bills have been passed. If any of these criteria have not been met, then the governors are duty bound to ensure that the passed law, the said law, is within constitutional principles and constitutional provisions.
Zaka, the governors have constitutional responsibilities. It is a constitutional post, but governors have, governors don't have this discretion that they will sit on bills that have been sent to them for their assent for multiple years. By the way, in the Tamil Nadu's case, I believe there are 10 bills. 2 of them are from the time of AIADMK's rule, not DMK's, AIADMK's rule. So the governors cannot say that we'll basically wait for a few years. We will not say anything. We will not send it to the president. We do not think this is unconstitutional, but we won't say anything. We won't do anything. That they cannot do. They simply cannot act as viceroys of Emperor Modi. I think some governors, maybe many governors, have basically gotten into their heads that Prime Minister Modi is Emperor Modi. He's not. He's not the emperor. You're not the viceroy. You have an obligation. And the Supreme Court is, quite frankly, the observations of the Supreme Court, any decent governor, any person who has some decency would resign. The governor of Punjab would resign. The governor of Tamil Nadu would resign. The governor of Kerala would resign. The governor of Telangana would resign.
Why?
The governor of West Bengal would resign.
Why? There have
Because-
been innumerable
because-
Supreme Court judgments that have chastised politicians, elected politicians. Have any of them resigned?
No, but let me just say this. Politicians who compete for the trust and votes of people, they're elected people, and if they do something wrong, and they're shown the door by the citizens, because in our system of democracy, the citizen is supreme. The citizen is sovereign, not Emperor Modi.
Salman,
Emperor Modi is
there
not
have been
sovereign.
instances of people, elected politicians, who have been convicted of heinous crimes, who have won elections from jail. People who have been convicted of murder and rape have won elections from jail. I mean, I don't think there's any greater constitutional propriety than someone who's been convicted of heinous crime continuing to get the people's mandate.
Zaka, if you have a problem with people winning who should not be winning, you take it up with the people of this country. But the Supreme Court is very clear in this. They say as soon as possible means that you have to expedite a decision.
Okay.
You cannot sit on this decision. Why are you wasting time?
Okay.
Basically, my sense is that all that talk by Prime Minister Modi when he became Prime Minister first about cooperative federalism, as with many other things about him, they're all optics.
Okay.
But in substance, what he has done,
that
his
point
undermined
about
state-
there has to be a
state
time
opposition
frame
views
within
states
which the governor has
time
to
and time
decide
again.
one way or the other. That is a point well taken. So, Kapil Sankla, I think that was the moot point, that governors were not saying no to bills, nor were they giving their assent. They were simply sitting on bills. And I think, like Salman was saying, in two of the bills, I think there are 12 bills that the DMK's petition the Supreme Court has cited. Two of those bills are from well before this government came into power. It is from 2.5, 3 years ago. So the point is that, do governors have the luxury or the constitutional elbow room to sit on a bill that's been passed? In most of these instances, these have been passed unanimously by the state legislature.
So, Mr. Zaka, let me answer it like this. That where the law is silent, it is open to interpretation. And every party will interpret it in a way that benefits him or her. We'll agree to that. Also, where there is a legislative vacuum, the Supreme Court or the courts come and fill it up till there is a law or an ordinance that is put into place. We'll also agree with that. Now, Article 200 said as soon as possible. That itself is open to interpretation. It was never interpreted till now. Now, the Honorable Supreme Court says that certain deference has to be made towards as soon as possible. However, there is no time frame. Now, let me read it the other way. As a lawyer who's in court every day, there is a judgment of the Honorable Supreme Court that on the criminal side especially, a bail shall be decided as soon as possible. Now, that as soon as possible is again open to interpretation and also depends on how heavy the board of a particular judge is. It could be 15 days, it could be up to 6 months. So you can't actually pressurize a judge to say, no, when you say there has to be a deference to it, as soon as possible is 24 hours. I read the same here, that respect has to be given, but that is the discretion of the governor. And you're absolutely right. I think the issue arose because of three basic issues, where either the governor was sitting on a bill, not deciding it, or he was withholding it. Now, in that, what really happened is that the Kerala government still went ahead and it passed the law. Now, that itself is not a deference to the powers of the governor, which are constitutional powers. So, let me look at it like this, that as far as the verdict is concerned, and I am now going to argue, everybody has argued in favor of the judgment, in favor of the state. Let me argue it like this, that the judgment, in my view, also underscores the governor's responsibilities and his role as the constitutional head as the custodian of the constitution, to make sure that the laws are followed, that the due process is followed.
Okay.
I mean, that also we have to agree with, because that's what the Honorable Supreme Court has also said. Let me put another point, that the Kerala's urgency in the matter, as far as challenging the governor's right, power or might, or the fundamental right that he has, somehow overlooks the need of the governor to take a balanced approach. So, as far as that act is concerned, it is a very dangerous act, because in certain cases, as the gentleman said, that he is to become a rubber stamp. That is a very dangerous argument to make as well.
Okay.
And as far as the third is concerned, taking everything against me, very importantly, you see, the thing about judgments is like this. It's a very strange creature. For every judgment in 5 favor, there would be 10 against me. So in court, we say that the judgment is a dual-edged sword. We don't know which way would it cut. And even then, you don't know which judgment is open to reinterpretation, review, or even a recall.
Okay.
So the Honorable Supreme Court today, of course, favors a certain view, but it also favors
Zaka,
the
10 seconds
view
to me,
of
Zaka. I want to
fundamentally
respond.
keeping the governor independent,
Okay.
powerful, sir.
Okay,
just a
Saravanan,
second.
quick response, and then I'll give
Independent,
Mr. Roy
powerful,
the
and
final
a
word. No,
custodian
but
as
Saravanan,
far as
the problem
law
is,
Zaka,
you know,
the
there are
gentleman here
bills,
says
there are bills the state
yeah.
may want to pass, which you can legitimately claim, okay, governors are not giving their assent, they're sitting on it. But a bulk of the friction between governors and states, whether it is in your state, in Tamil Nadu, in Kerala, in Bengal also, it all infamously starts from appointments to the posts of vice chancellors or other higher educational high posts, where there is a friction between governor and government. That is where this whole crux started from. That is where this whole controversy started from, even in the state of Tamil Nadu. So now my point is, you can't have the same yardstick for appointments in universities where governors are chancellors and use that same yardstick for bills which, like you said, legitimately affect the people of the state, and therefore the governors have no right to sit on those bills.
No. Zaka, that's what I made it very clear. See, who made them the chancellors? The state laws, the state statutes made them the chancellors, and the state governments have the power to amend that statute. I will make whomever I want. Let it be the governor or a peon. Whoever, that is why the people have voted for me. The people who could question me are the people of the votaries, not the governor. The governor is merely a rubber stamp. Let us take this argument.
I don't think that's accurate. We
have the President of India here. No, Zaka, let me finish this. Let me finish my argument. We have a President of India whose powers are akin to that of the governor. If the President sits on a bill, will the Prime Minister keep quiet? Will the entire cabinet keep quiet?
Okay.
Mr. Narendra Modi, the Prime Minister, is the Chancellor of Central University in West Bengal. So will the President oppose that?
So,
in a federal
I'll give Mr.
Prime
Tatagata
Minister
Roy
is to
the final word.
The same.
Governors
the Chief Minister is to
are
the state.
expected to have no more powers than what the President has when it comes to bills that have been passed by Parliament. If presidents can't sit on bills indefinitely, then why should governors have that luxury, or why should governors make use of this loophole in the law where the law has not clearly defined what is as soon as possible? Mr. Roy.
See, what the Supreme Court has laid emphasis on is the phrase "as soon as possible."